Hey guys, and welcome to today's video. Buckle up, because today we're dealing with an absolute genius who decided the best way to fight a protection order was to violate it repeatedly and then argue about it in court, like he's the second coming of Clarence Darrow after binge-watching half a season of Law and Order. So, here's the setup. This whole thing started when a lawyer sent a cease and desist letter on behalf of a client who happened to be in a legal dispute with the defendant's mother. Now, a normal person, someone with basic emotional regulation and at least partial contact with reality, would have either ignored the letter or handed it to their own attorney. No. Our hero responded to that cease and desist with a full-blown, frothing at-the-mouth tirade in defense of his mother. Filled with enough venom to corrode the envelope it was mailed in. And unsurprisingly, the lawyer, whose only crime was existing in the vicinity of this family, said, yeah, no thanks, and filed a protection order. And that's where the real stupidity begins. Because instead of backing off like any rational adult, our defendant decided to treat the protection order like a personal challenge. He doubled down, then tripled down. And now, here we are in court for the alleged violations. Everything else you need to know will be laid out in the hearing. And trust me, it's a long one, but every minute is worth it. This guy manages to hit every square on the bingo card. Arrogance, ignorance, misplaced confidence, legal misunderstandings, and just enough attitude to make you wonder how he hasn't been held in contempt already. Clip 1.
Fazio versus Nevin Cooper Keel, case number 23-00563PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this afternoon for the evidentiary hearing regarding an alleged violation of the court's personal protective order that was filed on or about June 10th of 2024. At this time, I'd invite Mr. Hengeveld. Would you like to place your appearance on the record?
Yes, good afternoon, Your Honor. I'm Jeff Hengeveld on behalf of Sarah Fazio.
Thank you. And Mr. Cooper Keel, would you please state and spell your full name for the record?
My name's Nevin Cooper Keel. First name spelled Nevin, last name Cooper-Keel.
Thank you, sir. And Mr. Hengeveld, this is your hearing on the alleged violation, so you may proceed.
Thank you, Your Honor. I have one witness to call, and that is Ms. Fazio. Ms. Fazio, can you please tell the court who you are?
My name is Sarah Fazio. My last name is spelled Fazio. I am the petitioner in this matter.
Okay, and are you a licensed attorney?
Yes, I am. I've been a licensed attorney for 24 years.
All right, and how did you first come to know Mr. Cooper Keel?
I sent him a cease and desist letter on behalf of the client I think it was on June 23 of 2022.
Okay.
That was the first interaction I've ever had with him. And
in response to your cease and desist letter, what was Mr. Cooper Keel's reaction?
He sent me a series, several, I don't know if I have the exact count, of emails to my office email address that were a little unhinged and made little sense. I did respond to, I believe, the first one, if I recall correctly, instructing him not to contact my elderly client and to please direct future correspondence to me. He then proceeded to send me several threatening emails that he was going to sue me, he was going to sue my law firm. I ignored those to my best of my ability. And then he started up again in, I believe, January of 2022 or 23, I'm sorry. I started receiving a litany of additional emails that were more unhinged and more, that he was coming to my office and I was going to get something from him and that sort of thing. And that's when I initially filed for the PPO.
And under that PPO, the terms of the PPO, what is Mr. Cooper Keel prevented from doing as it relates to you in contact with you?
he is not to have any contact with me. He's not to reach out to me in any way, not to send me things, come to my home, come to my office, appear within my site, that sort of thing.
Okay. And now we're here today on the motion to show cause for violation of the PPO, and I want to cover the factual basis for that motion. Were you represented by counsel in a lawsuit that Mr. Cooper Keel filed against you in Allegan County Circuit Court, that being case number 23-67017CZ?
Objection. Relevant.
Exactly. In a show cause hearing for a protection order violation, the court's job is to determine whether the defendant actually violated the order. That means anything related to the original protection or to why it was issued, what the defendant did or didn't do, prior communications, or attempts to contact the protected parties directly relevant. When the defendant tries to argue that it's irrelevant, they're misunderstanding the purpose of the hearing. The judge isn't reviewing unrelated matters. They're reviewing the factual and legal basis of the alleged violation. Without addressing the original PO and the defendant's actions in relation to it, the court can't make an informed decision. Essentially, if it's tied to the issuance or violation of the PO, it's fair.
Mr. Hengeveld.
Yes, Your Honor, this violation, the factual basis for the violation relates to contact arising out of the lawsuit I just referenced, where I was counsel for her, Ms. Fazio, and I'm laying the factual foundation for why there is to be no contact directly with Ms. Fazio in that lawsuit.
Insofar you're laying it in that your argument's going to be, well, that contact should flow through you as the attorney.
Yes.
All right. Response, Mr. Cooper Keel.
My response is that the Michigan Court Rules Chapter 7, Section 2 for the appeals court says that until an attorney files an appearance in that case, they are not representing the client. So for that to be relevant, he would have to be representing her in that case, because I think what they're getting at is that I served a copy of a motion from an appeal where she was not represented, not this other case he's asking about. So I don't see the relevance of the other case.
Okay. And response on wrong case argument, Mr. Hengeveld.
Yes, Your Honor. I was always the attorney for Ms. Fazio in her capacity as it relates to the lawsuit out of which the appeal arises. There was a motion for reconsideration filed. Whether it's my strategy or not to respond either to claim for interlocutory appeal or to not respond to a motion for reconsideration because it's not required to be responded to or not allowed to be responded to under the court rules. All of that doesn't obviate or vitiate my appearance on behalf of Ms. Fazio, my representation of Ms. Fazio. If that were the case, then you could make contact directly with a party and when they were represented by counsel. Clearly, that's not what the appearance rules require or provide for. In other words, I'm the attorney for Ms. Fazio. Mr. Cooper Keel knows that, and whether or not we chose to file an appearance in the Court of Appeals for an interlocutory appeal or not is not relevant.
Exactly. In the legal system, once someone is represented by an attorney, all official communications regarding the case are supposed to go through that attorney, sending documents directly to the represented party. Especially when a protection order is involved, can be considered harassment or an attempt to circumvent the legal process. For a pro se defendants, someone representing themselves trying to claim a loophole here usually doesn't hold up. Appeals are meant to review the decisions made in the original trial. If a party already lost or disagreed with the ruling, they file an appeal. But the presence of an attorney on record means that attorney is the proper recipient of court filings. Attempting to contact the represented party directly can violate ethical rules and, in the context of a PO, can be treated as
Okay.
PPO.
Well, and I would tend to agree with your argument there, Mr. Hengeveld, and that typically when a person has, what I'm going to call as actual notice, that is, they know that an attorney represents another person, they are generally precluded from contacting that other person directly. And the forum, that is, whether it's the Court of Appeals or the District Court or the Allegan Circuit Court or the Kent Circuit Court, is not the controlling factor there. It's the representation itself. I'll overrule the objection and allow the response.
All right, so the question again, Ms. Fazio, was, were you represented by counsel in the lawsuit that Mr. Cooper Keel filed against you in Allegan County?
Yes, I was. You were
Who was your counsel?
You were in Price Hunteville.
Okay. And as it relates to the claims against you in that lawsuit, what was the outcome?
I should say Plunkett County. I apologize.
Okay.
What was the outcome? The outcome of the underlying case in the state court was dismissed.
Okay. And then it was subsequently taken up in an interlocutory appeal?
That's my understanding, is that it was taken up in an interlocutory appeal. That's correct.
Okay. And what is your understanding of the outcome of that interlocutory appeal?
It was denied.
And after it was denied, again, I'm going to show you momentarily your some exhibits, but after it was denied, the interlocutory appeal was denied, do you know whether Mr. Cooper Keel filed anything further to address that denial?
Yeah, I believe he filed, and I can't remember what the document was called, but he filed a late document, or motion for reconsideration, I believe is what it was entitled, or something to that effect,
Okay.
With the Court of Appeals.
Your Honor, I can either put it up on the screen if you'll allow me to share my screen, or I can just reference it. These are just the exhibits to the PPO motion. What would Your Honor prefer?
Why don't you go ahead and display it on the screen?
All right. Ms. Fazio, can you see what I have displayed on my screen?
Yes, I can.
Okay. And what is that? What is this that's displayed on the screen?
The motion to show cause for violating valid personal or foreign protection order.
Okay.
It's the one that I filed in this case.
Okay. And what is Exhibit A to that motion? And I have it up on the screen.
It would be the motion to reconsider denial of appeal for lack of merit that Mr. Cooper Keel filed with the Court of Appeals.
And is there any particular part of the motion to reconsider that you consider to be significant or relevant to the PPO violation?
Well, I mean, initially I felt like it was a violation of the PPO because it was sent directly to me, as opposed to being sent to you as my counsel. You appeared on the Court of Appeals Register of Actions as my counsel from the moment there was a Court of Appeals action opened. Mr. Cooper Keel had to actually add me as a party on the My File case for the Court of Appeals, so that he could independently email this to me, as opposed to sending it just through the My File system, which would have automatically copied you and did copy you and all other counsel of record at the time. So I felt like the initiation of contact was both a violation of the PPO, and if you look at the content of the motion itself, it's quite inflammatory and violent. I look forward to whatever Trump does to the judiciary at paragraph 6, and I hope it involves the public executions he's recently talked about, French Revolution style.
Exactly. From the outside, it might look like she's just arguing her case, but in reality, sending anything directly to a person who has a protection order against you isn't about legitimate legal argument, it's harassment. Protection orders aren't just suggestions. They are court-enforced restrictions. No matter how clever someone thinks they are, trying to claim a loophole by mislabeling correspondence as legal argument almost never works and usually backfires. Legitimate appeals happen through the court system, not by contacting the protected party directly. The judge and attorneys are required to follow formal procedures. So bypassing them doesn't strengthen your case, it only creates more violations and legal trouble. It's a classic mistake where someone conflates technical legal knowledge with permission to harass.
Paragraph 7, I know 3 little punks, I don't know, that pretend they're trash lawyers breaking into my house lacks merit for them to explain. I eventually met the appellees, that's me, I guess, and of course they are also pathetic people. The same people would be dumb enough to concoct such a scheme against me, same dumb ones that get caught, same dumb mentality of judiciary to pretend this appeal lacks merit. I mean, this is just sort of, calls the court pussies. I mean, it just sort of is kind of the similar tone as all the emails that I received from Mr. Cooper Keel.
Okay, and then you mentioned this already, but let's go to Exhibit B. What is Exhibit B, and what was the purpose of you including it?
Exhibit B is the Court of Appeals Register of Actions that shows that you are my counsel of record and have been.
Yeah, and I point to page 9 of that, I guess 9 of the motion, which would include Exhibit B, indicating that I'm the attorney for both Ms. Fazio and her law firm, Price Underley. And then what is Exhibit C?
This is the my file receipt that Mr. Cooper Keel, that shows that Mr. Cooper Keel added me as an individual for e-service, and I guess no one else. So he wasn't satisfied with the attorneys of record, so he made sure he added me so that I would receive it.
And finally, what is Exhibit D?
Exhibit D is the email I received on June 10 from my file indicating that I was added to that case so that I would, and then attaching a link to that, I guess, motion for reconsideration that was filed with the Court of Appeals.
And for the record, that's June 10th of 2024 at 11:50 p.m., correct?
Yeah, correct. Most of his emails come in late at night, early in the morning.
Since this contact on June 10th, 2024, has Mr. Cooper Keel attempted or had contact with you thereafter?
Yeah, he attempted again on December, let me look here. I think it was December 2nd. I received an email from my file that stated that was, well, it's from my file, but it stated that Devin Cooper Keel was attempting to add himself as a connection to my MyFile account, which, had I allowed it, would have granted him access to all of my cases, all of my filings, and all of the cases that are using my file. And it would have given him access to my payment source, my credit card that's on file for the filing fees on the pleadings. And then on December 5th, I received an email from Debbie Brewer, who's an office manager in the old building I used to be in in the trust building at 40 Pearl, indicating that Mr. Cooper Keel was attempting to send me a package to my attention at my old professional address. I had moved out of that building in 2020, but I just instructed her to return it to sender.
Exactly. Courts are extremely clear and literal about this. No contact means zero. Not direct contact, not indirect contact. Not legal-sounding contact. Not I was just informing them. Not I labeled it as a filing, so it doesn't count. If the protected person receives something because of your actions, that's contact. If the protected person's attorney receives something, but it's obviously meant for the protected person, that's attempted contact. And if you disguise a message as a legal filing, the court will treat that as even worse because it shows intent to evade the order. Protection orders are written broadly on purpose so people can't hack the rules with technicalities. Judges look at behavior, not labels. If the message contains hostility, threats, accusations, or anything not formally required by a legitimate filing submitted to the court, it's a violation. Trying to mask a harassing message as a legal act not only fails, it proves the person knew contact was forbidden and tried to work around it, making the violation even clearer.
Your Honor, I don't have any further questions at this time. Thank you.
Very well. Mr. Cooper Keel, do you have any questions for Ms. Fazio?
Yes. In Exhibit B, the Register of Action, I didn't see a date as to when the attorney Hangeveld was added as counsel. Is there any date on Exhibit B for when that list was produced?
That list was produced on June 11. I printed that off the day after I received the 11-something p.m. email from you. So it was June 11 that I printed it. I don't know on the Register of Actions if he was ever added. I think it just comes up from the state court as every attorney that's of record in the state court.
Okay, so that was a register of actions from the state court, not the Court of Appeals.
No,
Correct.
that was just, nope, that's wrong. That was a register of actions from the Court of Appeals.
Can your attorney put it back on the screen and show it to me? Because first time I've ever seen that.
COA docket number at the top there on Exhibit B. That is the Court of Appeals Register of Actions from June 11 of 2024.
And when was the date that Mr. Hengeveld filed an appearance for you in that case?
I don't know.
What? I'm sorry, I didn't hear you.
I don't know.
And she did not know.
Okay. So you don't even know when you filed an appearance in this case?
I didn't file an appearance in this case. I'm a party, not a lawyer.
I mean, your attorney, Jeffrey Hengeveld, you don't know when he filed an appearance in that Court of Appeals case.
That was my testimony.
Well, your PPO complaint says that he did file an appearance for you in that case, doesn't it?
Asked and answered, Your Honor.
I don't know what, I don't have it in front of me.
Hang on, let me rule on that objection, Ms. Fazio. Response on asked and answered, Ms. Cooperkill, Mr. Cooperkill.
I don't recall when it's been asked and answered. In fact, they claimed that he represented her, but
Yeah, he elicited testimony that he was the attorney. Are you asking something different then?
yes, I'm asking when did he file an appearance?
I already answered.
And she
You're
already,
referring to the appeal in this matter.
All right,
that-
yeah.
I don't want to put words in your mouth. You might
She doesn't
say
know.
that.
She said she doesn't know when.
Okay.
So I guess, yeah, that's, I don't object or, want to push against the objection. They're right. Asked and answered.
You may continue, Mr. Cooperkill.
Exactly. In these hearings, the judge will routinely sustain objections from the attorney because pro se defendants or anyone trying to argue outside proper legal procedure often makes statements or attempts that violate rules of evidence or procedure every time the defendant tries to present irrelevant information, misstate the law, or make personal attacks disguised as arguments. The attorney will object, and the judge will almost always agree. It's the court's way of keeping the proceedings on track and protecting the process if you're watching the video. Expect to see a pattern. The defendant tries to speak. The attorney objects, and the judge sustains it. Over time, it highlights just how unprepared the pro se party is compared to someone who knows courtroom rules. And it reinforces the importance of having proper legal...
PPO complaint, you claimed that he had filed an appearance in the Court of Appeals?
I'd have to see the complaint. I don't know. He appeared for me from the moment there was a Court of Appeals action.
For an attorney to appear for somebody, don't they have to file an appearance?
she asks for a legal conclusion.
All I know is that he appeared as counsel of record from the moment I saw the docket at the Court of Appeals.
How did you get the Register of Actions from the Court of Appeals?
It's available online.
Where at online?
I'd have to go look up the URL. I don't know.
Okay. I'm just wondering where that came from, because I don't know how to get one for the Court of Appeals.
Is there a question?
How do you get the list of Register of Actions?
Your Honor, she already testified. Objection asked and answered. She already testified she does not know. She would have to look up the URL, which is not on Exhibit B.
Okay, and I did hear that asked and answered before, and she said she doesn't know as we sit here today, so you may move on to your next question, Mr. Cooperkill.
So how do we even know that Register of Actions came from the Court of Appeals?
Because I obtained it from the Court of Appeals website on June 11 of 2024.
Do you think it's possible maybe it's showing the lower court register of actions rather than the one for the Court of Appeals?
No.
Okay. So you said your first contact with me came in 2022 when you sent a cease and desist letter on behalf of your client, right?
Correct.
And I responded to that email asking you, how do you think I am harassing or trespassing on your client's property? Because wouldn't I have to first be doing something to cease and desist it, correct?
I don't recall every word of that email. Do you have a copy of it?
Yes, I do.
Okay.
Would you like to adjourn for...
No.
No. Okay. And isn't it true you didn't respond with anything to my request for you to describe how you think I've even been doing that to cease and desist it?
Objection relevance, Your Honor.
Okay. Response on the objection to relevance, Mr. Cooper-Keel.
Well, what she said about her email contact with me in 2022 is completely false in her own direct testimony. She said I sent threatening emails then. Now she doesn't remember what even was sent.
Your Honor, may I respond?
You may.
Well, while it's accurate that I did ask a question about, I guess, the foundation for the PPO, or at least my intent to lay a foundation for the PPO, and we're not here to relitigate whether the PPO was properly issued, and we're not here to relitigate the case against that Mr. Cooper-Keel had filed against Ms. Fazio's client in that lawsuit. So that's why I object on relevance.
Okay. Well, the question of relevance is with regard to are the prior emails and the content of those emails relevant. I think their existence is relevant because, after all, these violations would have come via an email notice of this register of actions. However, the content and the reasons they were utilized as the basis for the PPO are not relevant to today's hearing. I'll sustain the objection and ask that you move on to your next question, Mr. Cooper-Keel.
Okay. Then in 2023, in your direct testimony just now, you claimed I said to you I was coming to your office. Is that correct?
Something to that effect, yeah.
Do you have any copy of any email saying something to that effect?
The emails that are the basis for the PPO that were received in January of 2023 from you were attached to the PPO application. I don't have it in front of me, but if you want to show it to me, I'm happy to talk about it.
So, isn't there no email that's been submitted with your PPO application where I said anything about coming to your office?
I don't think that's true.
Your Honor, I'd ask you to. Do you think it'd be fair? I guess I shouldn't ask the judge. Do you think it'd be fair for the judge to take judicial notice of what you filed and that it doesn't contain anything about any?
Exactly. Judicial notice is strictly for facts that are not subject to reasonable dispute. Things that are either generally known or capable of accurate and ready determination from reliable sources. For example, a judge can take judicial notice that a certain law exists, that a calendar date fell on a Monday, or that a court document was filed on a particular date. What a judge cannot do is take judicial notice of something that requires them to make a conclusion or judgment, like whether someone's actions were illegal or whether a claim has merit.
Judicial notice, that's not the purpose of judicial notice, because it would have Your Honor make some sort of judgment or analysis of what the content of the PPO email is, rather than a judicial notice, for example, an unobjectionable fact such as the date on a calendar or things like that.
Okay, and with regard to judicial notice, it's typically taken of facts or legal pleadings or something of that nature that's filed but not in dispute. Of course, the factual contents of all of those pleadings may or may not be in dispute at any given time, so they're typically not subject to judicial notice. So I'll deny the request for judicial notice at this time. I am able to consider it for evidentiary purposes. You may consider with your next question, Mr. Cooper Keel.
Okay. So the entire basis for this complaint of a PPO violation is that the state's automated email system from the Court of Appeals emailed you a copy of my motion to reconsider in a civil case against you. Is that correct?
No, that's not correct. The basis for the violation that I filed not only is the fact that you went out of your way to add me as a contact to a Court of Appeals action and make sure I received the document that you filed, which was not only untimely and unwarranted and apparently had no basis in law. But then the content of the document that you filed was additionally inflammatory, aggressive, inappropriate. I believe you were sanctioned by the Court of Appeals for even filing it. And then, of course, the continued harassment that's continuing that I received on December 2nd. I received additional harassment on December. I think that called me, and pardon my language, Your Honor, because it's as appalling and disgusting to me as I'm sure it is to the court, but I believe that one referred to me as an old cunt, I think, I don't know, scores of times. And then the December 5th attempt to reach me in my office as well. The continuing violations are adding up, and I desire no contact. You've been ordered to have no contact, and that's why I filed the motion that I filed for violation.
Now, I thought you said whatever was sent to your office address on December 2nd that they contacted you December 5th about, your office contacted you, right? It wasn't me that called you to tell you something arrived?
There were two separate contacts. There was one on December 2nd where you tried to add yourself as a connection, which would have allowed you to make filings on my behalf and access my payment source in my file. That was December 2nd. December 5th, I was contacted by an individual who worked in my old building saying that you were attempting to deliver something to my old building. So those were two separate instances.
That I was personally attempting to deliver something, or the mail was trying to deliver something?
I wasn't there. I don't know who was there standing in her office, and I just said, return it. I don't want it.
Okay. So how do you know whatever was in it? Because you just said whatever was in it called you an old cunt, but you said you told them to just return it. You don't want it.
That document was filed with the Court of Appeals as well, and I don't know what was in the December 5th package. I only know about the December 2nd attempt to add yourself to my file account. I reached out to my counsel, and I think at that point in time he said, oh, there's even more filings in this Court of Appeals, and this is what they are. And that's when I got to see that you apparently had filed the offensive pleading in court. And I don't know if that's why the attempt was made on December 2nd. It was around the same date, though. When
did you discover about what you refer to as the offensive filing in court related to this December 2nd or December 5th event?
I don't understand your question.
When did you discover this offensive document you just referenced?
I believe my counsel provided it to me around that same day, around December 2nd. I don't know, it might have been December 5th. It was around the same time where I reached out to counsel and said, hey, he's still attempting to contact me. He's attempting to become basically my legal assistant by becoming my connected user on my file. And so when I reached out to my counsel, and that's when he said, well, this just showed up at our office, and it's more of the same vitriol that has been filed in the Court of Appeals and what's been contained in the emails.
And so what was the title of the document?
I don't remember.
Do you remember what type of document it was at all?
It was a pleading filed in the Court of Appeals.
What type of pleading?
I said, one that's out of time, I don't know.
So you're a lawyer and you're a party to this appeal, right?
I don't know. Here's the thing. The Court of Appeals has ruled. I don't believe there's any open matter before the Court of Appeals. I think there's some filings that you're making that are attempting to file late things in the Court of Appeals for the purpose of name calling, and for no other purpose other than that, in my estimation. And that's what you're filing. Does it have any legal basis or merit, or is it the kind of thing that normal attorneys would file? No, it is not the kind of thing that attorneys would normally file.